to French, and from also English to Spanish. You can see the interpretation button in the bar down on your screen. And the Russian is today the Finnish interpretation. So you can find the Finnish interpretation under the Russian interpretation bar. I'll say this in Finnish as well. Sä löydät siis suomen kielen siitä käännösnappulasta alhaalla, missä lukee Venäjä, Russian. Sieltä voit laittaa suomen kielen tulkkaus päälle. There's a globe icon, and under the globe icon, you can find the interpretation. You can also raise your hand at the reactions button on the bar, and also we will have questions and answers where you can ask and discuss different questions. Okay, there's anything unclear with the practical, please just let us know in the chat. And from there, I would like to really, this is such a great opportunity to spread some valuable information about the Istanbul Protocol and how to assess and how to get familiar with the Istanbul Protocol in general. We have great speakers today. Pérez is here. Kim Baranowski is here. Also Hugh Macleod. And they will have some presentations, and then we'll have some discussions, questions and answers after each presenter. I wonder, because this is today done with the cooperation between IRCT and the Center for Psychotraumatology in Helsinki. So I wonder if we have Mari Tikkanen online already. If not, then I'll just go ahead and let you all know that this is partly funded by the EUSA funding from the European Commission. So now we can start the first presentation. It's really my pleasure to introduce Kim Baranowski. Dr. Kim Baranowski is a licensed psychologist. Oh, but I think we did it in the way that Pau would go first. Wasn't that the thought? So let's do it that way. Okay, so then we start with Pau's presentation, Dr. Pau Pérez, which might be quite familiar to many of us. But Pau has quite some history, because he's been a consultant at the Department of Psychiatry in the University of La Paz, Madrid, since 1906. He's contributed to different popular organizations in Latin America since 1988. He's the clinical director of the SiRa network for assessment and rehabilitation of victims of violence. He's the director of the postgraduate diploma in mental health in political violence and catastrophes. And he's the former chair of the section of psychological consequences of persecution and torture at the World Psychiatric Association. And He's also editor-in-chief at Torture Journal. He's a forensic expert in national and international courts for victims of mistreatment and violence. And he's also training in forensic documentation of ill treatment and torture, according to the Istanbul Protocol. Please, Pau, the floor is yours.
Thank you very much for your introduction. I understand that most of you have already had some knowledge of the Istanbul Protocol or are using it. And the idea today would be to stress some points which I think are especially relevant when trying to document torture. Probably in your trainings, you have been faced with hundreds of slides touching many concepts, and the idea at the end is that this seems to be a very complex process and that you need, a lot of training. And my idea today is trying to say the opposite, trying to say that that with a very basic training you can dare to document torture, and that in spite that an Istanbul Protocol can be a very complex process and a very complex report, it can also be a very straightforward and easy report provided certain conditions. So trying to go against fears of doing Istanbul protocols. I know you come from very different contexts. Probably those of you which work in Finland mostly document torture because you work with refugees. In other contexts, people document torture linked to criminal proceedings, and in any case, the structure of the protocol is slightly different, but the essential elements are the same. And this is what I want to stress here, which are the essential elements that we have to consider for an Istanbul Protocol. And this will be independent whether we have a 3-page report or a 300 pages report. This will depend on the context, the complexity of the case, and other circumstances. You know that there is an updated version of the Istanbul Protocol that was launched in 2022. The new version is, well, the handbook is quite a lot longer, but the core elements of the Istanbul Protocol remain unchanged, basically unchanged. In the new updated version, you will find big development of legal aspects. There's a huge increase in legal aspects. There is a strong reinforcement of ethical elements of the Istanbul Protocol. I think there are repeated advices to prevent misuse of the Istanbul Protocol, which is something that we have detected in some countries. And I would stress that there is a very clear chapter 4 on interview aspects that is suitable for doctors, for legal, for lawyers, and for all people, all professional profiles linked to the documentation of torture. When I say advice to prevent misuse of the Istanbul Protocol, I mostly refer to 3 situations that were that we saw before. One is the use of the Istanbul Protocol to deny the existence of torture, in that idea that if you don't have psychological or medical consequences, then there is no torture. And the Istanbul Protocol remarks once and again that no symptoms doesn't mean no torture. And there are many more elements to document torture. We will go briefly to that later. And the need that the assessment is done by with the psychological and a medical side, and both are combined, and there is a consensus, and the higher level of consistency of the medical or the psychological side is the one that should be in the final agreed conclusion. The other problem that it was detected was using the Istanbul Protocol to discredit the victim. And now there is strong advice against that, in the sense that, for instance, there is a clear advice not to use personality tests to discredit the survivor, or to use the psychosocial history regarding, for instance, gender identity, use of tattoos, or any other element that could give a negative image of the survivor to the court or the administrative authority. And finally, also advises against making a non-credible conclusion, and gives additional reassurance that if you think that the testimony of a victim is non-credible, you need the opinion of a second expert, and both should agree on that before giving a final. So it's additional safeguards for an ethical use of the Istanbul Protocol. When you work in a day-by-day with the Istanbul Protocol, there are always ethical tensions. One of the ethical dilemmas I find more often when doing trainings is that we pretend that the Istanbul Protocol, that the process of doing an Istanbul Protocol is a process that has a healing value, that has, from the point of view of rehabilitation, has a positive effect on the survivor. So we do things in a way, and the new version of the updated version of the Istanbul Protocol makes a strong emphasis on that. We do things in a way that we stress the do no harm elements in the way we do interviews, in the way we work, the control we give the survivor over the interview, or how we give feedback. And probably Kim will enter more in depth in this. And this obviously creates an ethical tension. I've worked with in national institutions for documentation with forensic national institutions, where they have a long waiting list for people waiting for an Istanbul Protocol, and they say, okay, that's very nice, but what happens when I have to do 3 Istanbul Protocols per day? So there is a tension between what we would like to do and we can do, and how we take care of the survivors. And this is, in the front side of anything we do. But at the same time, try to make a good process of assessment, and this balance in which, in spite that we have a lot of pressure and a lot of people waiting for assessment, we never forget that we are working with very vulnerable population, and population that needs to be cared in all the process. So empathy and caring for others should not be in contradiction with objectivity and with a good work. I told you that an Istanbul report and an Istanbul Protocol can have 3 pages or 300 pages. This means that the Istanbul Protocol is just a guideline on how to document torture, but it's not, a kind of cooking recipe that you have to follow step by step. And sometimes this is a misunderstanding. Some people think that you have to follow Annex 4, which is, the annex in which you have an example of what could be a final report. And some people think that you have to follow this point by point. And if you do that, you will find out that this is a nightmare, that it's a long list of bullets to be filled. And it's unrealistic that you can, it's unrealistic and it's unnecessary in most cases. So this is just a suggestion of how a report can be. And part of the skills in doing Istanbul protocols is selecting which parts of the Istanbul Protocol are essential for that case, and which is the important information I have to collect. Whether, I need a higher standard of proof because it's a criminal proceeding, or I need a lower standard of proof because it's, an administrative process. Or, for instance, we are in the framework of a reparation process, and then the focus is not on the clinical side, the focus is on the expectations for reparation and what is important for that person. So there are different focus, and I have to make a preliminary decision depending on the case, depending on the legal context, on where to put the focus, and which is the complexity that I need for the Istanbul Protocol. And for any document to be compliant with the Istanbul Protocol, we need basically that it complies with two sets of elements. One set of elements is the ethical standards, the ethical requirements of the Istanbul Protocol. And this is something you have summarized in Annex 1 of the Istanbul Protocol. And there are some additional elements in other parts of the protocol which are not in Annex 1, but that can be put in relation. And basically, these ethical elements have to do with one, security. We are responsible for the security of the survivor. This is not probably a problem in Finland, but surely it's a problem in many other contexts. Or it might be a problem in Finland if you are doing an interview in a prison and there is a risk of reprisals. So it's our concern not to put the survivor in risk. And this is something we have to put in clear in our report. Second, privacy. We have to make the interview, with privacy, which are the conditions, not to have anyone in the room that can be coercive to the person. And confidentiality means who will have access to the report. The report belongs to the authority that has asked for it and belongs to the survivor who has ownership on any medical document related to her or to him. And of course, informed consent, which can be written, which can be oral, and of course is a very basic requirement. There are some additional ethical requirements which are stated in this, which basically have to do with that idea during the assessment, the do no harm principles, and acting always in the best interest of the survivor. So doing a good report is not a justification to have an attitude that can be hard, that can produce harm in the survivor. So these are the ethical requirements. We have to document in the first page of the Istanbul Protocol that we have, been compliant with all these ethical requirements. This can be one page. I mean, it's not a complex thing. It's the second is the technical requirements, ethical requirements, technical requirements. Which are the technical requirements? Any report must have at least 4 elements. One, we must identify who is the survivor, the name, date of birth, passport number, whatever. Second, we have to explain what happened in one paragraph or in 10 pages. It will depend. But in any case, in the words of the survivor. So we should not paraphrase. We should not use any other words than the ones that the survivor uses. So this means quotations and taking notes exactly of the words of the survivor. This is her version of what the one we collect. In the global process of researching on torture, there will be other people who will also make a declaration, probably the police involved or other actors. But in the Istanbul Protocol, is the survivor the person who is in the center, and we must collect in her and his words what happened. Third, the symptoms and signs, medical symptoms, psychological symptoms, both should be in the report. Always we should include both medical and psychological symptoms. And finally, which is the level of consistency between one and the other. This is the account of events. This is what I found out. And then, which is the level of consistency you have already seen in your training process. There are 4 levels of consistency in the psychological assessment, 5 in the physical assessment. In any case, the level of consistency between both. That's all. That's all. If you do that, this is according, the document you produce is according to the Istanbul protocol. If you just have 20 minutes and you are in a prison and no more than that, you can do very basic, but you can do a document which is compliant with that, provided you have taken care of the ethical principles. If you have 6 months to work on an Istanbul protocol for a strategic litigation in a very complex international case, you also do the same. The basic elements of the Istanbul protocol are the same. So again, the Annex 4 is just a guideline, but you need to be creative. You need to think what really you need for that context, and then adapt the purpose, the strategy of the Istanbul protocol to your needs in that context. So that's on the one side, and I will never stress enough the idea of the forensic documentation as a healing or reparative process. And I know this is something that in many places it's difficult to understand, especially when you work from official institutions. But it's important. I will not go in depth into that because the next presenter will go on how to do the interview. But empathy, but what the Latin American friends call the vínculo comprometido, the committed bond with the victim, that idea that we are working with human, which is in front of the thing that we position in front of these abuses. And sometimes some things that are not going to read it between lines, which is that sometimes you have to switch between being a forensic expert and being, perhaps not a therapist, but someone who can provide a crisis intervention, who can, stop the process of documentation and to stop the assessment and to work from a therapeutical point of view in trying to help the person who is in an emotional outburst or a difficult situation when making the assessment. That is a protocol, have a free conversation with the survivor to wrap up the process, to explain what has happened, which is my impression, and to stress all the resilience elements we have seen during that process, so as to give a positive ending to the work and a kind of psychological closure that makes that it's not just taking information for a report, it's taking and giving. And in this process there is a rehabilitation work. Well, just some additional elements. I don't have much more time, but I would like to stress at least two or three points. One, that idea that no symptoms, clearly a wrong idea. Many times we do not have symptoms, and because it's a long time since the torture happened, or because every time more torture, psychological torture, and it's done in a way that doesn't leave marks. So this is really a challenge. It's a challenge to see how to document torture when we don't have scarce, we don't have clear symptoms. One mistake that will be developed in the next presentation is to think that all torture survivors should have PTSD. PTSD is a very popular diagnosis, but it's not the most frequent consequence of torture. There are many other elements: chronic depression, insomnia, substance abuse, many other clinical symptoms that you can see after torture. But there is the expectancy that we should find PTSD. PTSD has cultural problems. There are many reasons why we should be cautious about the use of PTSD. But of course, PTSD also has advantages, and this is probably why it makes such a it's so interesting. Also, we said that part of the challenge we have is to put in a relationship the account of events with the symptoms we find. And PTSD makes it quite easy to make this causal relationship. If there are intrusive symptoms, images, nightmares, whatever, and the contents of these images or the contents of the nightmares can be clearly related to the allegations, this is, very helpful in making the final consistency analysis. If you have avoidance symptoms that can be clearly put in relationship, also this is very helpful. Or if you have panic attacks, hyperarousal, whatever, when you see elements which clearly can be related to the allegations, this is very helpful. So rather than in itself, the important thing is which are the symptoms we see that can be put in relation with the account of events and can help in making this final consistency declaration. I should mention related to that sometimes we need to go further than a consistency analysis, and we must do a credibility analysis. And this is, that I know that some people is reluctant to do that, and this is why I want to at least devote 1 minute to this. Making a credibility analysis, it requires some, additional information that we don't have in that basic analysis that I gave you at the beginning. For doing a credibility analysis, we include changes in psychosocial history, for instance, how the life of the person reflects the impact of torture. We see the consistency between emotions, between body responses with allegations. We see clinical symptoms. We have the triangulation with other sources, for instance, witnesses. For instance, you have video recordings or you have other reports. You have to assess the context, whether, the person has negative consequences of denouncing torture, and this is, a strong credibility element. Or, of course, you can have psychometric assessment, although no psychological test is reliable for doing a credibility assessment. But you have many elements. And I know that some experts are reluctant to the credibility analysis because they say, one, this is a responsibility of the court. It's the judge who must do that. Second, I put myself in a very difficult position, because it looks like, I'm judging the person. And that's a common mistake. When you do a credibility analysis, you're not judging the person. You're doing a credibility analysis of the account of events or a credibility analysis of the symptoms. For instance, if the person was drunk, you can say that the account of events is not credible because the person was under the influence of alcohol. So I'm not judging the person. I'm judging the circumstances and judging the final result, the account of events, and the symptoms. So that's on the one side. On the other, the Istanbul Protocol now says that you should make a clear statement on whether what you have seen in the report could be considered ill treatment or torture. So you can make clear to the court that the Istanbul Protocol asks you to do that, and this is not something that you choose to do and go beyond your level of expertise. This is a requirement of the Istanbul Protocol. And third, and this is an ethical question, you know that torture many times happens in closed places with no witnesses and with no way to document torture if you don't have any kind of physical scares and the credibility analysis and the Istanbul Protocol is the only tool that the victim can have to prove what she or he suffered. So we have an ethical commitment to answer to the situation of this survivor, and simply saying no, I don't do that because I think this is going too far away. It's a way of protecting myself, but it's also a way of not answering to the needs of the survivor. So there is even a risk to the survivor if I do a weak Istanbul Protocol. I just make, uh, a very basic protocol without a credibility analysis, because I think that this will have a negative reaction from the court or from the administrative authority. In the credibility analysis, it's what helps us to support the case when we don't have enough symptoms, medical or psychological symptoms, to make the consistency analysis. That's one possibility. The other possibility, Kim will talk more about that, is making a resilience analysis, is to try to explain why there are no symptoms based on which are the elements in infancy, in coping mechanisms or other that can explain this absence of symptoms. Of course, this is not the best possible solution, but it's something we can do when it's difficult to make a consistency analysis. And finally, there is also the possibility to try to document what I call the non-clinical symptoms. The non-clinical symptoms is basically, for instance, the impact in terms of secondary emotions, guilt, shame. These are elements which can, change the life of a person, and there is no clinical diagnosis in the DSM-5 or that corresponds to these emotions, or changes in worldviews. Again, we don't have a clear diagnosis that can, complex PTSD sometimes, but we don't have a clear diagnosis that can cover that, or the impact in terms of family, community, whatever, or identity. So there are other elements which are non-clinical that can also help us to support the case. And we need to know, to be comprehensive and to have a holistic perspective so as to try to best document tort. So just to wrap up, the idea that that doing an Istanbul protocols should not be a complex process, that provided you comply with the ethical elements, the 5 ethical elements I have stressed at the beginning, and provided that you identify the victim, you make the count of events, you find the physical and psychological symptoms, and you make the consistency analysis, this is enough. And this is something that can be done by a GP, that can be done by any health worker, or in some circumstances, even there are some studies that lawyers alone in a prison are able to collect this very basic information to make not an Istanbul protocol, but at least a document which is compliant with Istanbul Protocol principles, and that can be an initial document of what happened to the survivor. Okay, I will stop here. This is just some, ideas to share with you, and probably we'll have time to discuss later after Kim's presentation. Thank you.
Thank you so much, Bob. This was so interesting. What I found that you really lower the pressure of making a perfect report or anything like this, that many would have like high standards and high criteria. So this takes a lot of pressure away from especially healthcare workers and other workers as well, to be able to do in that situation as much as possible. So thank you so much for this. Anyone would have any questions now, or as Paul said, we can take them after the presentations as well. Okay, then could I move on and present Dr. Kim Baranowski? Again, a licensed psychologist and researcher who works in the field of trauma, forced migration, human rights, and global health. She serves as the Associate Director of the Mount Sinai Human Rights Program, which offers comprehensive pro bono and holistic services to asylum seekers to the United States who have experienced persecution in their countries of origin. Please, Kim, the floor is yours.
Thank you so much. And hello, everyone. I'm so happy that you're joining us today. I'm going to share my screen because I have a few slides. I'm going to be talking a little bit today about the nuts and bolts of the psychological evaluation. And primarily, I provide forensic evaluations. So I am working with individuals who've been exposed to torture, persecution, and ill treatment, who are seeking protected immigration status in the United States. So as Paul mentioned, there is a wide variety of psychological symptoms or responses that we can see in individuals who have been exposed to torture. And those range from, symptoms of kind of somatic complaints, so people reporting pain as opposed to psychological distress per se. Folks may experience psychosis. Folks might experience substance use. But despite this wide range of symptoms, we very frequently see common sequelae of exposure to torture and ill treatment. And in a large meta-analysis, so they were looking at studies with survivors of torture and persecution, the kind of three primary kind of symptom clusters that we typically see, that is not to say there aren't many, many more that we still assess for, are symptoms associated with post-traumatic stress disorder, depression, anxiety, and then to a smaller degree, psychosis. So very often when we are working to document the mental health correlates of exposure to ill treatment, these are very often the typical findings that we uncover. So one of the things that we might be asked to do when engaging in a psychological evaluation is to speak to the impact of exposure to trauma on an individual's memory. And this is very important because, as Paul mentioned, credibility can be a defining factor in whether someone is determined to be truthful or not. And we also know that trauma can have very specific impacts on memory that may undermine the perceived credibility of a particular individual. So individuals who've been exposed to torture may have difficulties, for example, recounting specifics of their experience of torture. And that might be due to issues of neuropsychiatric impairment. So for example, if someone has been beaten in their kind of to the head, if they were suffocated, this may impact, of course, their ability to remember the situation. But also protective mechanisms such as coping, so avoidance or denial of events, can also be taking place, as well as kind of cultural factors. So cultural norms that would, instruct or dictate whether a particular individual discloses their experience of persecution and to whom. So when we think about trauma and memory, there are a few things that would be helpful for us to keep in mind when doing an Istanbul Protocol evaluation. One is that traumatic memories are typically fragmented. They are often very difficult for an individual to arrange chronologically. And this sometimes is a hallmark of credibility, is that folks can say very clearly, this happened first, then this happened, then that happened. We know that traumatic memories may be suppressed altogether. People really cannot come in contact with those memories. So when we think about inconsistencies in the trauma narrative, there may be opportunities to provide education and knowledge to the judiciary or other bodies of how inconsistencies may be reflective of exposure to trauma rather than particular problems with credibility. And lastly, traumatic memory can appear to change over time, in that the process of relating these experiences can be gradual. So an individual's kind of story of their exposure to torture may shift over time as they are able to communicate more of that narrative. So that's something that we can really do to help support an understanding of why individuals who've been exposed to torture may behave in ways that are unexpected to folks who are maybe not trained or very knowledgeable, as well as how their memory can be impacted by these experiences. So when we think about the Istanbul Protocol guidelines, when it comes to the psychological evaluation, there are many questions that we may be asked to answer. Most often, are the psychological findings consistent with the individual's report of torture? As well as, given that symptoms related to trauma can fluctuate over time, they can increase or decrease depending on the individual's perception of safety. Where is the individual in this arc, this kind of wave of fluctuating symptoms? So why is it that the individual might be reporting fewer symptoms now than earlier, or more symptoms now than they were just a while ago? So there are many questions that the Istanbul Protocol guidelines can support us in answering related to reports of torture. As a psychologist, of course, and anyone working with individuals who've been exposed to trauma, we're concerned about re-traumatization. So we really want to work to ensure that our interview, our time with a client does not kind of trigger emotional reactions that will overwhelm their coping strategies in the moment. So essentially, we want to do several things, which I'll speak to in a second, that can help us kind of support the individual so that they are not overwhelmed with fear, anxiety, or feelings associated with the original trauma that can cause the client to relive that event during the evaluation. So how do we do this? And there's many ways. Pau spoke to the importance of developing a strong alliance, a strong working relationship. Although it is important to document evidence objectively, it is still our job to be empathic and supportive so that this experience, although not designed to be therapeutic, can still be as positive as an experience as possible. And it is common for the clients that we work with to say, you know, it was hard talking with you, but there's a part of me that feels a little better. You know, talking and sharing and having someone bear witness to your story can be powerful, and it can be therapeutic, even if it's not therapy. So how do we do this? How do we engage in trauma-informed interviewing during an Istanbul Protocol evaluation? We support clients' control as much as possible. We follow their pacing, their levels of comfort with disclosure. We work very carefully to track their affect or their emotions that are observable to us. We are very attuned to changes in affect that may give us evidence that the client is becoming flooded with emotions. We engage in check-ins. We check in constantly. How are you doing? Do you need a break? Would you like some water? Would you like a snack? Do you need the bathroom? And when needed, we facilitate grounding exercises or kind of strategies in the moment that helps the client feel present centered. So they are here with us now. They are not back there then, and in as much control over themselves as possible. Because a flooded client, we're not going to be able to get the data that we need to complete the evaluation. So it's always a balancing act between being supportive, getting as much information as possible, but helping the client to stay kind of intact and organized. So just a tiny bit about the structure. Informed consent is very important for many folks. For clients, this will be the first time they are meeting with a clinical professional who does this type of work. So being clear about how this meeting differs from other meetings they might have with doctors, with psychologists, who will have access to the information is very important. So clients can determine for themselves how much they choose to disclose. We provide a typical clinical interview, which I'll talk about in a second. We move on typically to the trauma narrative from there. We may include screening instruments, and we often, in my program, end with a needs assessment so we can connect the client to resources and services. So anyone who is a mental health professional and even physicians are very familiar with the clinical interview. We engage in a lot of history taking, because in many cases, the experience of violence or torture may have roots in the entire lifespan, specifically. So we look at developmental, occupational history, of course, their medical and psychiatric history, and we typically wrap this part up with a mental status exam. Now, the Istanbul Protocol guidelines really support us in kind of putting together the part of the interview where we elicit the trauma narrative. So we want to offer kind of an open-ended inquiry. So we don't want to ask a lot of close-ended questions if we don't need to. And then for clarification, we may go back and say, okay, you mentioned that when this happened, you noticed A, B, C, D. Can you tell me more about that? So for the purposes, I should say, of forensic evaluations, we often have the client's declaration. So we have their trauma narrative that's already been worked out with their lawyer ahead of time, and that can support us to do as what Powell recommended, focusing on the necessary elements. You may choose to include standardized measures. We've found in the United States, judges appreciate that. They believe it helps to increase our credibility and our trustworthiness as evaluators. So you may choose to use measures or instruments, tools that assess for trauma symptoms, symptoms of depression, anxiety. We also sometimes will use measures that help us kind of articulate identity over time. So for example, sexual orientation over time, so that we can help clarify who knew about a person's particular affections, in which contexts they were out, and so on. Another important piece is a cultural evaluation. So how does this particular experience of torture, how does it fit into the worldview of the client? Because we know different experiences are going to be viewed as differently, potentially traumatic, based on someone's cultural background. So being unclothed in certain ways can have different valences or different meaning depending on an individual's cultural background. So we think about what are the salient cultural issues. To what extent, if someone is in a secondary country or a third country, for example, folks in the United States who had experienced torture in their country of origin, to what level are they acculturated to norms here? And how does culture impact help seeking or support? Now, resilience is essential. And although sometimes it can feel like we are focused so much on the quote unquote problems associated with the exposure to torture or persecution, all of our clients are demonstrating resilience. I mean, they've made it this far already. So we always consider all of the different ways that the client is effectively coping, ways that they might be able to move forward in their lives, things that might be protective factors that might minimize the likelihood that they would present with symptoms of PTSD, for example. We can also think about strengths-oriented questions, and this is another way to guard against re-traumatization. So focusing on accomplishments, things that the clients have done to help cope with painful feelings, getting a sense of how cultural or spiritual practices support them. And this is something we can also include in an evaluation, which can help communicate why a particular individual seems to be potentially doing so well in spite of everything that they have been exposed to. So in conclusion, and I'm happy to answer questions in a little bit, we know that torture can lead to significant psychological outcomes, and sometimes these symptoms have implications for perceptions of credibility in forensic settings. We can assess for these outcomes in a trauma-informed way, and the Istanbul Protocol guidelines really provides us with a helpful tool in which to do this. Thank you.
Thank you so much, Kim. Any questions or comments at the moment? This was really interesting. It rose again a lot of thoughts here when it comes to assessment. Okay, if not, then I have maybe some, but we can do those later on. It's really interesting again. And then if still no questions, I will be moving on to Hugh. Hold on, let me introduce you, Hugh. Hugh is a communications leader at the IRCT. And IRCT is 164 members in 76 countries, are global leaders in the documentation and rehabilitation of torture. So before joining the IRCT, Hugh qualified as a barrister at the English bar, having completed a master's in international human rights law at Oxford University. He was a visiting lecturer at the University of Law and was formerly a Middle East correspondent for the British and American press, based in the region for a decade. So you have quite an interesting background, Hugh. And
Thanks, Lotta.
please, the floor is yours.
Great. Hi, everyone. I will share my screen in a moment. After those fantastic presentations from Pao and Kim, we've actually come to 3:30, but I'm just going to plow on. We are recording the session. I will very much understand if anyone needs to leave. I'll be sad to see you go, but you can catch up, of course, with the full webinar on the IRCT website, and then later on, we make our Insights product, which is a kind of short version with what I hope are the best parts of the webinars. So let me just try and get this right. Share sound, here we go. Okay. Everyone seeing that? Yes, great. Well, here we are. You, me, and the IP. Making a difference together. I'll say Jambo. Greetings from Nairobi. As you see, I travel with my precious copy. It's got sellotape on it. It's full of highlights and marks. So I will try to take us a little bit into the document itself and introduce you to some of the tools that IRCT developed to educate people on the IP. And also, as Pal really opened the gates there, to say that this is a document for all of us in this sector who may potentially come across a survivor of torture. By way of introduction then, so in a galaxy far, far away a long time ago, gosh, there's me, fresh-faced, at least journalist, there is a reason to introduce these. Then there's me and my dear mother. In the UK, you qualify as an utter barrister, which kind of sounds like an insult, and it sort of is after all that work. And then here I am, so proud. I'm now the communications lead at, importantly, a health-based organization. There's my email address if you want to stay in touch. And please, as the sign says, learn more at irct.org. The point being, as a journalist, then lawyer, and now working with a lot of doctors, I've been very interested in how the IP is applied and what it's all about. So, is the IP for me? Well, are you a health professional? Probably. So, the answer is yes. How do we know? We can turn to chapter 7. It's a new chapter in the updated. It's the role of health professionals in documenting torture. Paragraph 604, I won't do too much of the reading out, there's a lot in here. As stated above, regardless of employer status, state or non-state, or work setting, custodial or non-custodial, all health professionals have an ethical obligation to document and report alleged and suspected cases of torture and ill treatment. So our Swedish colleagues came to Copenhagen not so long ago from the Red Cross and expressed reluctance, concern, apprehension about documenting torture, because they were approaching it, as Pal mentioned, from this is a criminal litigation matter. You know, I don't want to prejudice a future trial. Everyone's very concerned with alleged crimes in this and this circumstances. But if you're familiar with legal procedure, you're not going to make the judge's mind up or the jury's mind up. You're there to provide evidence, which may go into a trial. But unfortunately, in most circumstances with torture survivors, you're not going to get a trial. But what you need to get is the evidence of what happened to them in a coherent, consistent, best practice, internationally agreed manner. And that's what the IP does, because there's more than just criminal prosecution. There's civil remedies, reparations. And then there's just the basic web of accountability, you know, that these crimes don't go unremarked, don't go unrecorded. But if you don't really believe me, let's listen to, and I'll just play it inside here. Hope the sound comes on. Dr. Nora Sveas, Norwegian professor. I'm not sure if she's still on the subcommittee for the prevention of torture, but she was at the time.
I think what the chapter 7 tries to do is to place the importance of the Istanbul Protocol on the ground, where professionals, health professionals, are working on a daily level and on a daily basis. It is to try to engage with professionals who are not necessarily very aware of torture or have not working in places where often the issue of torture or treatment has not come over the radars, to say it that way. And we're speaking about addressing health professionals working in emergency settings, in migration settings, in centers where asylum seekers are being held, either detained or in open centers. We're speaking about people working in regular hospitals, general practitioners, and all of these settings where we know so well that people may come with experiences of torture or treatment, but where it has often been not considered as their duty to look more into it. But now this is a way to really communicate with everybody in the health profession, saying that this is your duty too, and referring, of course, to the international standards, but also to the moral obligations enshrined in most of the...
I'll leave it there. You can, of course, watch all these videos at the IRCT YouTube channel, youtube.com/IRCT. There's a section on the Istanbul Protocol. It's now about 50 of these videos, questions and answers. What is the Istanbul Protocol? What's in it? Why is it needed? Who's it addressed to? So are you a lawyer, such as myself and some respects. Is the IP for you? Yes. You won't be giving any medical opinion, but you are involved in the documentation of a very, very serious crime. The most serious, according to international law, absolutely prohibited everywhere and always. So if you want to find out something about new standards.
The first might be the fight against terrorism and the way that torture has been used as part of that fight against terrorism. There have been
We're short of time. So anyway, Chris Esdale is the senior legal advisor at Redress, strategic litigation and reparations for torture survivors. He certainly thinks you should be using it. It's also a fantastic document if you just want to remind yourself of all the ways in which the treaties and the courts have prescribed prohibited torture and the international obligations on states. That's just chapter 1. Let's crack on because we are short. Are you a journalist? Aha, as I was, maybe still am. Yes, you should also be using the Istanbul Protocol. And we've touched on this. Kim was talking about the way to ask questions. And so it's a very important, very useful guide for everybody in almost any kind of setting in which you're going to take down a person's story of trauma. That you have these guidelines in the IP. They're a little bit spread around. So, and this is as yet a draft, so please don't share this publicly, otherwise Asker will have my head on a platter. Oops. But I have tried to prepare what I call the Investigating Torture and Ill Treatment by Interviewing Survivors short IRCT guide based on the IP. And after this session, we will share my slides, everyone's slides, and I hope you can find this useful. It really gives you, what's the purpose of investigating this? And as Hal was saying, we've got to get to the facts with an aim of identifying perpetrators. How do we do this? Statements, evidence, witnesses. When we're interviewing the victim, we're taking the statement as a journalist. And the idea is that there is a way to question people, even if you're not going to be, involved in some kind of UN Human Rights Council investigation into massive atrocities. You should still be doing it this way in all circumstances, because, as Kim said, these are people who've gone through very serious trauma, and you do not want an interview to feel like an interrogation. So the information we really need are circumstances, dates, description. Description is such an important part. What can they remember from the place, the objects used? You can ask about sensory, remembering sensory experiences. And of course, you want to try to find out all the different forms of physical injury. You're not likely to be doing much psychology as a journalist, but of course, people will be talking about those things. I've put the paragraphs that relate to the IP, so hopefully I'm not just making this up as we go along. Just very briefly, doing a good interview, of course, informed consent. They need to really have written down that they understand the purposes of the interview and where it could be broadcast. We have a consent form, which is kind of an opt-out. They can just say any part of it, I don't want that disclosed, or my second name, or my whole name. I've done interviews where I have the survivor in silhouette, because it's still important to have people's experience, their first-hand experience. Oh, thanks, Mohammed. Okay. Mohammed's taken over sharing fine. No.
It's
Okay.
just because, sorry to interrupt you, you were showing the PowerPoint still, the presentation, so I'm just showing them how the
Right.
in the website.
Good, thanks. Okay.
Just let me, I'll give it back to you.
Yeah. Let's just go up a little bit. Okay, just here, Mohammed. What kinds of questions? Just these. No, sorry, Mohammed, go down a bit. Second page. Oops. Okay. Building trust and rapport. That is. Yes. Okay. Sequencing questions. That's part of the IP process. Is, you know, you don't jump straight into, you were tortured in prison, weren't you? Closed question with a narrow answer. Yes, no. That's a leading question. And here we come into why training as a barrister was suddenly quite interesting, because actually in court, when you do the evidence in chief, as we call it in common law, you can't ask leading questions. You have to establish the narrative. So these questions, explain to me, describe to me, please, what happened, who was there before, when that happened. Why is not a productive question usually? You know, why were you tortured? And then, you know, to get even a bit more sophisticated, but I think it's within everyone's possibility, is trying to understand the impacts. So this is where you do intersect a bit with the psychology, without treading on the toes of the health professionals. But, you know, what were you thinking about? How did your life change? They can be quite simple ways of, and this is just good interviewing. And I realized, you know, as in my, 20 years ago as a journalist, I was doing lots of interviews and somehow getting it right sometimes, but I had no idea really that there were guidelines for these kind of things. And probably I should have done that. But when you're in your 20s, you don't think too hard, you just plow on. Particular questions in very specific situations. Mohammed, if you just go down to the third page. The IP also covers, and this is very important, situations of special consideration, children and survivors of sexual violence or torture based on gender identity or sexual orientation. So we don't need to go through them all yet, but obviously when you're talking to a child, non-leading questions is even more essential, because a child will try to please you with their answer if you suggest things to them. And obviously with sexual violence and that stigmatization, torture, if you do have a person who's, you consider has probably been raped, you can ask a useful question, something around it, like, did the officer remove their clothes at any time? So, you know, the IP has these sort of suggestions on how not to practically traumatize the person you're talking to. So the IP, to recount, yes, it's for health professionals. Yes, it's for lawyers. Yes, it's for journalists. Mohammed, maybe I'll go back to my slides. Sorry, thanks.
Go ahead.
I knew that was going to come a cropper. Here we go. Is the IP for me? Well, just briefly, we can say again. Oh, this is. Okay.
The point about this is a document not just for governments. This is a document for everyone. And if we can get every medical association, every nursing association, every psychological association, every lawyers association, every journalist association, how powerful they can be, to actually recognize that there is this document. It is a book of reference. It will point out what you need to think about when you are faced with a dilemma. And that is the strength of this new document.
There we are. Dr. Vivian Nathanson, UN Voluntary Fund for Torture Victims, at the launch of IP 2022. So it should be clear, should not be reluctant to get a hold of this lovely blue document. So what do we do now? Get your own copy. I won't go through to the links because it'll take us away from the, but here's the link. Download it. It's in now English, Russian, and French. So any Russian speakers there may be here could be useful.
We will have the IP translated into Finnish, the whole IP translated into Finnish also by the International Day of Prevention of Torture around June. So just to mention that as well.
Yeah. And then, of course, I do like an old-fashioned print. You know, apparently if we plant trees and then harvest them, we are doing the world a service. So paper's still okay, maybe. You can actually order these for free from the UN shop. And when I went in there, when I was in Geneva, the guy couldn't believe it. No one ever goes in there. No one ever just picks up all the documents. But they're there, the professional training series. And you can do it just by contacting them through that link at their website. And you just say, we're doing training on IP, we're from a health-based or legal-based organization working with torture victims, survivors. Please post us 10 copies. They're really useful to have around, I think, because I don't know about you, but always going back to the screen can be a little bit eye-burning. And then take a browse. I have actually tried to compile a question and answer on the IP based on which paragraphs are talking about the same theme. I think Pao might agree with me that some of it is repetitious and perhaps not laid out structurally in the most perfect way. And if I complete that, I will share that with the email group for this webinar. But if you take a look at the difference between paragraph 355, and this is to go to what Pao was saying about there's different IPs. I'll just read briefly. Important to note that clinical evaluations in non-legal contexts do not require an interpretation of the level of consistency between the clinical findings and the allegations of torture or ill treatment, or an opinion on the possibility of torture. Nevertheless, in these non-legal contexts, clinicians who have knowledge and experience of applying the Istanbul Protocol and its principles should still consider providing an interpretation of the level of consistency. So for clinicians in non-legal contexts, you're not obligated to make that perhaps difficult assessment of the consistency between the evidence you found and the allegation of torture. But if you're doing a medico-legal evaluation, which is the full IP, you know, it's like fifth gear IP. Paragraph 384 says very clearly, medico-legal evaluations that fail to assess and provide an opinion on the possibility of torture or ill treatment are not consistent with the Istanbul principles and should be considered deficient. So, you know, if you're doing the medico-legal, then you need to make the assessment. Otherwise, it's not a medico-legal report. But if you're documenting torture as a health professional or a journalist or a lawyer, you can still do a very important service. The second part, and this will be very short, a little bit of example of IP in action. You know, what kind of difference can it make? As we said at the start, IRCT has member centers all around the world, so IP makes huge difference in many different settings. In Mexico, they were using the IP, as Pao referred to actually prevent the proper investigation of torture. They were saying only state forensic examiners can use the IP. And of course, the state forensic examiners are kind of in bed with the state perpetrators of the torture. So they say, yeah, that bruise probably fell down the stairs. So the IP needs to be done by independent practitioners to challenge that. In this example, which is something kind of close to the British situation, here we have Nazanin Zaghari-Ratcliffe, who was a British dual national. She was in Iran, working for a development organization, arrested by Revolutionary Guards on the accusation of being, oh no, of all the worst things, a journalist and other crimes. Sentenced to 5 years, and they basically state kidnapping, you know, the Iranian regime linking it to the UK paying off an old debt for tanks not released. And what does a good old UK do? Well, we watch as Nazanin is sent to Evin prison, amnesty documents in Evin prison, the systematic torture, beating, sexual assault, deliberate neglect, no medical treatment. So what happened? Redress, one of our partners in the United Against Torture Consortium, teamed up with IFEG, which is a service of the IRCT, the Independent Forensic Expert Group, who are doing the medico-legal fifth gear IP stuff, you know, the forensic evidence analysis. And two of our experts from IFEG, these two wonderful ladies, did an online 2-day forensic examination to determine Nazanin's physical and psychological condition. So as you know, as we talked about earlier, like this was the big deal. You know, it's not 20 minutes, quick session, 2 full days, a really comprehensive evaluation. And their finding was that from these disorders that Nazanin was suffering from, it's consistent with her allegation of torture in Iran. Redress presented this to the cheeky chappy Dominic Raab, once Foreign Secretary, now hopefully just sitting around in a pub regretting all his bad decisions. He's a Tory. He had talked, and the whole UK policy had talked about Nazanin's ordeal, which, you know, it certainly is an ordeal, but torture is a different thing and triggers a different obligation. Just a few months after Redress's massive report, 77 pages, Raab and others were referring to Nazanin's treatment as torture. Boom! It's in the Times, BBC, Independent, The Week, an editorial. Nazanin describes torture. As James Lynn, our IP lead, likes to say, it wasn't actually news. She was always being tortured. It's just that now we've got proof, as it were. And after that, the UK just paid the ransom, paid for the tank debt, and Nazanin was released. Did it make a difference? Here's James. He would say, of course, there's geopolitics, but the use of this substantiating the evidence of Nazanin's torture was highly influential in pressuring the UK government to do something. As you'll know from talking to, I know most people will be working with refugees, but those states that torture don't often like to admit or even investigate. So they deny. But if you use the IP, you have that force of the international standards behind you, and you can confront the state. It's not merely an allegation, it's evidence. Just very briefly, now I've gone over time, another different circumstance here is, and this is so great to see, this is the front page 1 of Republic of Philippines National Capital Judicial Region Trial Court Branch 70 Taguig City. Captain Sherwin Williams, Guaidangan. Who is this guy? Well, he's a guy that tortured another guy. He was in the Philippines Army, and he thought that Abdul Bakr Ajid, was a member of the proscribed terrorist group, Abu Sayyaf. And him and his soldiers did really horrible things to Ajid. All the physical torture you can possibly imagine. We had been training a medical action group in the Philippines on using the IP, and their assessment went into evidence, and this guy was convicted. A very long time, 2011, perpetrated, 2023, convicted. And it's only the second ever conviction under the new anti-torture law. But the great thing is it sets the precedent. You know, it breaks the wall of impunity. There's a crack in the wall. And usually when there's a crack in the wall, you can start pushing it apart a bit more. So I'll leave it there, but I'll share the slides. There's some things to follow up on there. I hope you find it useful. Thank you very much.
Thank you so much, Hugh. Any comments? any questions, any thoughts? Take a look in the chat. Muhammad has shared some materials there as well.
I mean, maybe I could start with a question for the participants. I mean, can anybody describe to us, the panelists, I think it would be useful for us as well, to understand the role of torture documentation in Finland? I mean, I'm supposing Finnish authorities aren't systematic perpetrators of torture. So you're dealing with refugees. We know 1/3 of refugees on the whole have been tortured. And so you're dealing with asylum processes. You're evidencing the allegation of torture to prevent return to a state, refoulement, to a state where they're likely to be tortured again. Can anyone give us a sort of, illustration of work in Finland? How the IP might fit in?
Would anyone feel free to go ahead? I know we have a lot of Finns online today. As you know, Finns are not that talkable.
Finns are notoriously reticent.
Good example.
They're the happiest people in the world, but
we might not be that chit-chatty of us, yes, but that's exactly what's going on in Finland right now. We have presented the IP, of course, the Rehab Center for Torture Survivors, the Center for Psychotraumatology, has for many years provided information about IP and how to do assessments. But there's also personnel changing a lot and new coming in. So we are constantly educating. And the IP project, the IP project in general also made a new e-learning course that maybe Heidi might put in the chat if Heidi is still around. So then you can also find the IP e-learning course, unfortunately only in Finnish so far, but we hope that we can launch it maybe in other languages as well. And this is an overall basic course. So there's quite much that we promote and educate the Finnish social and healthcare personnel and also the legal. But as Hugh, you mentioned, there's not such a tradition of like maybe thinking of journalists as well. So that's a nice inclusion as well. Yes, but I think maybe I'm speaking then for all the Finns. I would love to hear some more comments from other Finns as well.
Hi, I don't find how to raise my hand. Sorry, I'm Marianne Laine from Refugee Advice Center, and maybe I think you pointed out well, Lotta, what is the situation in Finland. And well, when you asked you, I think mainly where we should use more actually the IP. And where we need this practice is in this asylum procedure mainly, and also in other immigration cases, when, for example, victims of trafficking are applying residence permit here in Finland. But like Lotta mentioned, it's not very well known, and I think because of that, also a big thank for you for the great speeches, what you mentioned now, because I think and what also was said in the beginning by Paul, that, it's not, even if it seems to be very difficult and very long, protocol, it's not so difficult to use it. to be and what also Lotta mentioned, and Kim, you know, it's only important that we are brave enough to work with these cases and try to also point out the main principles what are there behind, and yeah, like to take care of the victims and well, but that's it. So we need a lot of these, and the problem is that it's quite difficult to get. Still, the problem is how we get also the authorities who make the decisions to also understand the value of these this evidence, to see it really as evidence in these cases. But okay, this only shortly. Thank you.
Thank you so much, Mariana, for your comment. Any other comments?
We have one in the chat from Mina.
Mm-hmm. Mm-hmm.
She writes, the challenge is with training professional in many fields, for example, municipal integration support staff or states reception centers, etc.
Yes, yeah, exactly. That's right, Minna. And that's why we now did the e-learning course. So personnel can, whenever they have a possibility, do it. So that's a great start. But then there's a lot that needs some hands-on work as well on really how to do an assessment. So we are dreaming of opening a lab where you can also do the assessments, but we must dream big and then see what we can make of it.
Can I make a comment?
Yes.
I'm going to open my camera. I'm going to be very bold. It's very early in Vancouver.
Okay.
This is Mariana. I started my career in Argentina, and I've been practicing in Vancouver for the last 20 years. And I want to add a brief comment. I'm aware of the time. I see survivors and I work to support them directly, and I also clinical supervisor. I want to say that as someone trained as a psychotherapist specialized in trauma, I think we need to be extra committed to navigating the dilemmas or the challenges of being trained in trauma therapy, where we know that it's not about eliciting facts in order to heal or to promote movement and getting out of the stuck of trauma in the body and in physiology. But at the same time, when confronted with the work with survivors, we need to document facts. So for a clinician, maybe, I don't know, I don't want to speak about someone else's experience, but maybe if lawyers or other professionals do not have that dilemma of dealing with facts and with the story, navigating these pieces that may seem like contradictions. So psychotherapists, we need to embrace that and document while following the patients or clients, the survivors' pace, right? In terms of how much access to the story they have. As someone that does therapy, but at the same time writes lots of psycholegal documentation for the Immigration Refugee Board in Canada, I know that it's possible, and we can conduct very healing therapeutic interviews that document facts and at the same time move the trauma in the body. I feel very passionate about this. I am very happy to be sharing the floor with the people passionate about this worldwide. I see the effect that this has in therapy and in determination, immigration determination processes. It's great to have this tool to continue revisiting it. I remember when I was first exposed to the tool, I was in Argentina many years, fast forwarding, and it keeps to be expanded. So it's very early. I'm still in my pajamas, as I can see, but I appreciate the opportunity to witness the work of others. And yeah, just sharing that perspective of the therapist and the one tasked with documenting. Thank you very much for the opportunity.
Thank you, Mariana. Such a great comment, really great comment there. Mm.
I'm gonna close my camera now. You don't need any more of me at 5 a.m. Oh, 6 a.m. already.
Thank you. Okay. Mindful of time, I'm really wanting to thank everyone who joined this webinar. Thank you to the interpreters. Thank you to Mohammed and IRCT and all the speakers on behalf of the Center for Psychotraumatology in Helsinki. This collaboration has been great, and I do hope we can continue with more collaborations in the future. Thank you, and have a nice morning, afternoon, evening, wherever you are in the world.
Thanks a lot, Lada.
Thank you.
Thanks to everyone who attended. It's really gratifying to see. We had over 100 participants at one point. That's fantastic. Kim, thanks so much also to you. Nice to meet you. And
Such a pleasure.